Welcome, everybody, to another episode of the Three Seasons podcast. I'm your host, Tyson Nagasaka, and today we have a special guest on that we tried to make happen in November because it was Make a Will month, and we were both super busy. We couldn't make it happen, but here we are in December. We have Kam Grewal with RDM Lawyers in Abbotsford on. Cam's the team lead for Wills and Estates on the team, and he's also the director of SEEN, which is the Certified Executor Advisor Network, which is another way that I was connected to Cam, and I really wanted to make this happen so we can have a chat. Cam, thank you so much for coming on.
No problem, Tyson. Looking forward to it. Thanks for having me on.
Yeah, no worries, no worries. So like I was saying, kind of in the setup to try and get this going is everywhere I was turning, I was seeing you, right? So we met a couple of years ago at a foundation, like mingler with like drinks and appies and things, and that was for the Fraser Valley Hospital Healthcare Foundation. And then my business partner, he's in your neighborhood, and he's like, "Yeah, I know Cam. Cam's a great dude, and we're trying to get more in touch with you." And then I did my CEA designation and get all the membership stuff come through. And I see that you're the director for Western Canada out here for that. And so it's just another connection. So I'm really happy that we could make this happen and have a chat.
It's nice having these connections that kind of come from different angles, right? Like it's like I know you from different areas, so it's good, right? The overlap. Yeah.
It is, yeah. It's so funny because the longer I've been doing the business and the more people you meet, the smaller the marketplace actually seems. It's like you're connected to people in so many different ways. And
Yeah,
sometimes you don't even know.
absolutely. Yeah.
So one of the things that we wanted to do to make happen was really do an episode to talk about wills and why people need wills. So it's a super common question when financial advisors, accountants, and lawyers meet with clients. One of the first questions is do you have a will? And most people don't say, yes, I have a will and I've reviewed it and I know what's going on. But what's your take on that? What's your experience with people and having their will done?
It seems, I mean, people are sort of trending in that direction that they're recognizing the need for a will. I mean, because I can kind of go on and on about this, but there's just like a number of reasons why one should have a will. I mean, from the ability to have an executor appointed, because when a person passes away and like your family's trying to make inquiries with the institutions, like, so and so passed away, what kind of accounts did they have here? The bank will often not release information unless you actually produce to them a will showing that your name is named as executor. And so even a spouse can't start making inquiries unless she's actually named in the will as executor, right? So that's usually the first thing that any authority will ask for. And then, I mean, other reasons why you should have a will is that there's the legislation in BC says that if a person passes away without a will, part of the estate goes to the spouse and part of it goes to the kids. And there's this assumption that maybe everything will go to the spouse, but that's not actually the case. The legislation isn't set up like that in BC. Part of it will go to the children. And if the children are under the age, then the public guardian and trustee will come in and hold those assets, which is a big disadvantage to the surviving spouse when they should have probably received the entire estate.
Yeah,
So they can not only look after themselves, but also the children as well. Right.
of
So,
course.
yeah.
So in those situations where the assumption is made everything's going to transfer to the spouse, um, where that does happen, do we just consider that like under the radar? So everything transferred over to the spouse, the public trustee didn't get involved. Don't talk about it, don't bring it up. Like, did they just luck out on that, or is that can happen
Uh,
sometimes?
no, it happens, right? So, like for example, let's say the individual passed away and they had a bank account at a bank, and now the bank is saying you need to obtain a grant of probate before we release these funds. So during that process, when the surviving spouse is trying to get an estate grant, uh, they will have to notify the public guardian and trustee that there's minors in this estate, and now the government is alerted to this estate and they're going to ask for information what's contained in the estate, right? And
Right.
so Now, when you're eventually getting the grant and getting those funds released, they're not all going to go to the spouse because the government already has their hands in it. They already know of these funds, they already know of these minors, and they're going to say, well, what's the portion that's coming to us to hold for these kids, right?
Okay.
So it's not something that you can just kind of run away from. It's a big problem when you don't have a will. The government does get involved depending on the nature of the assets, right? So it, yeah, it's not under the rug.
Yeah. Okay. That's good to know.
Yeah.
Maybe the ones that I've seen, they've just had everything in joint name or joint right of
Well,
surrogacy.
that's totally different, right?
Yeah.
Yeah. If assets are joint, that's completely different. They don't form part of the estate. But if you happen to have an account here or shares in a company, because shares often aren't joint, you might have a limited company set up that you use
Yeah.
for your business. Usually those shares are solely in your name, not joint. And so those would form part of the estate. And I mean, even there can be ways around it. But why jump through all these hoops when you could have simply just had a will done that directs everything to the spouse anyways, right?
Exactly.
So, yeah,
Okay. That makes a lot of sense.
yeah,
Something that I hear from, I hear it less, but I would hear from like my single dudes that are doing their retirement plan and we're doing whatever. Is I don't have kids, I don't own a home, I don't have debt. Like, why do I need a will? And I think you kind of hit on that. But for those,
well, where do you want it to go, basically, right? Yeah,
yeah,
yeah. Why let the government dictate where your assets should go? I mean, you've spent a lifetime earning this up and do the simple will and just direct it to the beneficiaries. I mean, in cases like that, the will is probably going to be fairly straightforward, actually, right?
yep,
There's no competing children that, so and so was involved in the business and so and so wasn't, and how much I give to this child versus this child. It's probably much simpler in that case, right? So,
yeah,
yeah,
absolutely. That's actually a great point. In the cases where there's multiple children involved, and maybe you don't divide the estate equally, like a third, a third, a third, but maybe there's different reasons for distribution and different sizes. Maybe somebody's better well off and somebody's not as good at managing money.
yeah.
If that's not done correctly, though, I have heard that sometimes the courts can re-equalize the estate. Is that true?
Yeah, that's right. In BC, there's the legislation that allows a spouse or a child to make a variation claim against a will if they feel they haven't been provided adequately for. And so, if they feel like they're getting a lesser share or they should have gotten more, they certainly have that right to make a claim in BC. And so, if you as a will maker are starting to um, plan your estate and you want certain children to receive more or certain children to receive certain assets, then there is certain things that you can do like trusts and holding assets jointly, perhaps, depending on the scenario. Some work better, some don't work as well. It depends on the facts. But there are tools that you can use to sort of protect your estate or those particular assets against claims. Yeah, it is something that it definitely is worth consideration when you're going through that process, right? If children aren't being provided for equally.
Yeah, yeah. And I guess that's where an expert such as yourself would be involved in, the planning side of it before you just like throw a document together and sign it. Um, having somebody that you can go to with questions and say, how would this work? How would it play out? Uh,
Yeah,
I think it makes
yeah.
a
I
big
mean,
difference.
at a minimum, we want to identify the risks for them and then give them the tools, right? That these are tools that you can use to uh, uh, sort of mitigate the risks here. And then it's up to the client, right? If they, depending on whether they think there's a significant risk of a challenge or not. Not every will that's unequal is going to get challenged because it really depends on the children as well, right? And the relationship between them and their parents and the siblings, and maybe there's just an understanding and so forth, right? But
Yeah,
you need to know the risks and the options around that. Yeah,
that makes sense.
yeah,
Um, Something that we see a lot, especially like on our end in the investment space, is the challenge from clients. They want to do it themselves versus use dedicated investment management. But we also see that in the will space where people want to do it themselves and, buy a DIY kit or download one or do something.
yeah.
A lot of times I think people just don't know the risks of doing that. So, very simply, like from your point of view, what are some of the risks that people can, maybe open up for themselves or for their estate?
The, I mean, the major risk to start is that if it's not properly executed, then it doesn't meet the definition of a will in accordance with WESA. So I'm dealing with, so this is one that I've dealt with in the past year or so. This was a will made by the person. They typed it up themselves and they signed it. It wasn't witnessed in accordance with the legislation. So before we could even start the estate grant process, we had to first make an application to court to even have this proved as a will.
Yeah.
So now you're incurring those extra fees to prove this will, make the application. Once the court approved it, only then could we actually start with that document and proceed with the grant. And another one that I actually have on my hands right now is this person had a will, and the original was stored somewhere else, and then but they had a copy of their will,
Okay.
and so on that copy, they started marking up the paragraphs and changing the percentages and crossing out beneficiaries. And so again, not properly executed. So the first step will be we got to now prove this will through court, make the application, which is going to cost thousands in fees. And so before we even can do the normal stuff that we do as far as getting an estate grant, there's this extra added step at the beginning, which I mean, it could simply be avoided, right? Doing a basic will is not that costly. Doing those applications is very costly,
Yeah. That
right?
sounds,
So yeah, it's just not worth it. And then I mean, just the drafting itself, like you make sure you have to draft the clauses properly. Is there an interpretation issue? What did you mean by this? I mean, that's what we do as lawyers, right? Like we look at words, we reword them, we play around with the sentences, we make sure it says what it is intended to say and to achieve the objectives. And I mean, that's what you kind of get when you go into the drafting process, right? And avoiding the kits and such.
yeah, that makes sense. What
Yeah.
what's the difference between like one of those DIY ones and the definition of the term of a holographic will?
A holographic will is one that is handwritten, so you basically
Okay.
write it in your own hand. It is, I mean, it's possible now in BC to have a holographic will because when the legislation changed about 10 years ago, those wills can be proven in court. Like they still have to be proven through court, but it is possible to get away with them.
Okay.
Whereas in other provinces, yeah, you can have holographic wills. And then do it yourself is, I think, my understanding is that it's just a kit that you kind of fill in, but it's not customized to your needs or your wishes. You're just
Yes.
filling in blanks, and hopefully you fill in the right blanks. And yeah,
Yeah, right. That's kind of scary.
a bit of
Um,
a risk, yeah, especially when it's your wealth that you're dealing with, your savings, your assets, and your family. And why do you want to mess that up, right? This is an opportunity for now you to leave a bit of a legacy to help the next generation that, you want to see benefit and take the time and just again, it doesn't have to be a costly process,
yeah.
right?
That
Yeah.
that's wild. I just had a guy on the podcast yesterday. He's a financial advisor in Toronto, and he said that he was just dealing with a family, a $1 billion family with their business and all of their investments and whatnot. No wills in the family. Nobody had wills. And
Oh gosh.
yeah,
Yeah.
and
Yeah.
you just think, why is that? And
Yeah.
it's a terrible thing to hear, but from your experience, what do you think? What is the resistance for people doing a will? Is it addressing or dealing with the possibility of end of life, or is it something else?
I think so. I mean, I think some people it just might be a bit of a fear, now that I've prepared a will, I might like something might happen, right?
Yeah,
It's just, why am I setting myself up for, like it's just not the way to think though, right? There might be a bit of that. And then also just not having an understanding of the planning process that maybe they think it's actually a very difficult thing to do, but it's not, right? Most of our wills, I can tell you like 90, 95%, 2 meetings and it
okay,
gets done,
yeah,
right? So it's not a very long process. Yeah.
that's awesome.
Yeah.
One of the things that I noticed in your bio was you're a trust and estate practitioner, right? And you're the wills and estate team leader. Online, we deal with a lot of US based financial advice where people are just saying, hey, just put everything in a trust and you'll be fine and you'll avoid tax, do all those things. In Canada, do you see a lot of families utilizing trusts the way that we were maybe in the 80s and 90s?
Um, yeah, I mean, there is tax with trusts here. So it's the US is a totally different system, right? It's
Yeah.
they're like I can't even start, how different they are. But I mean, in terms of trusts and tax here, it's not a tool to avoid tax altogether, but it can be used to reduce taxes, right?
Okay.
And but I mean, because trusts file their own tax returns,
That's right.
right? Just like how an individual files a tax return, a corporation files a tax return called a T2, you file a T1 personally, T3, it's a trust return, right? So there are tax returns that trust file, so they are paying tax. It's just that you're potentially reducing the amount of tax paid by those, right? And then from an estate planning perspective, um, we might suggest trusts um, to address the situation that we talked about earlier, wills variation claims, right? That
Yeah.
this might be a tool to use to protect certain assets from wills variation claims. Because if you transfer an asset into a trust, then it's not part of your estate anymore, right? And so it's less likely to be subject to challenge. So that's where trusts kind of offer some benefits.
Okay. Okay.
Yeah.
That's interesting. Um, what, well, when you're working with clients and you see that they've already had some work done potentially, do you review their wills and make adjustments or layer advice on top of that? Do you find that happen a lot in the industry, or maybe another lawyer's done something and their work's maybe not up to snuff, or do you see that a lot?
Uh, I mean, we, I mean, clients will come in and have their wills reviewed. Most often it's existing clients,
Yeah.
but it can be new clients as well that we review drafts for, or review existing wills for. Um, I mean, the way I kind of like to address that is it really depends on what the client's coming in for. If they have an existing will somewhere else, and really all they're coming in is that maybe they want to change executors, then we just define that as a scope of work, right? Because I mean, I don't want to incur unnecessary fees for them either if they're not interested in that. But if they are looking for a second opinion or a whole review, then yeah, we will certainly do that. I mean, it's not our practice to kind of critique the work of others, but we will suggest things that we've identified, right? Like, oh, we think you could do this, right? And or we think this might work better based on what you're telling me right now that your objectives are. Because I mean, they might have stated their objectives as something else to the previous council, right? And maybe what they drafted at that time warranted uh, based on the objectives. So, yeah, we'll certainly do reviews either way. And yeah, it just depends on what the client wants.
Okay. That's fair. That's a great answer, actually.
Yeah.
It's tough. It's a tough role. I know, like for us as financial advisors, some years it feels like all we do is fix other advisors' work, and some years you come along and you can say, hey, listen, you're working with a good advisor. Don't let another advisor come and change this because you'll reset your rates, you'll do all these things, but that doesn't happen often. So it's nice to hear that on the legal side, it's pretty tame in comparison.
Yeah. 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 We're certainly not. I just think that's just the way the practice is that you don't know what was discussed with the previous council, right? And yeah. Yeah.
Awesome. Um, One of the things, like when I was going through my CEA designation, one of the things, a phrase that's used over and over again is having a legal and valid will, right? So asking clients, hey, do you have a legal and valid will? What are some ways that are fairly simple that people might overlook that can invalidate the will and all the work that they've put into it?
Oh, it would, the execution usually ends up being the biggest issue, that it's not properly executed. And
Okay.
so in BC, the legislation specifically says that the will maker must sign it. It must be in the presence of two witnesses. And then those two witnesses together must sign it as well in the presence of each other, as well as the will maker themselves. So that's critical. And often most wills that require an application to court to be proven, usually missed something along the way in regards to those requirements. And so the two examples I gave, that was the issue there, right? That the requirements weren't met. So that's what a legal and valid will is meant to me, is that it's been formally executed. Yeah,
Okay. Okay.
yeah,
That's awesome.
yeah.
Um, when you're going through the advice process with a client, like what are some of the general questions that you would be asking the client, and then what are some of the ones that you normally field where the client comes in, they have a list of things that they want to ask you. What are kind of like the top general ones that you deal with on a regular basis?
Just I guess working through our estate planning process, we usually try to get an idea of the family. So spouse, children, grandchildren, figure out who's who and what the relationships are. And then also another important aspect is figuring out what kind of assets we're dealing with. So what is going to pass through the will? What assets do you have that might not pass through the will? Do you have companies? Do you have foreign property? Do you have interest in trusts? Because some of these things might suggest other opportunities for planning, or maybe other advice might be necessary. So just going back to like foreign assets, for example.
Yeah.
Um, so while we can make a will here in BC, and the intent is that it applies to all of your property, if you do have foreign assets, the administration of that asset might be a bit complicated, relying on a BC will because it's in a foreign jurisdiction.
Yeah.
So we might suggest that perhaps there be a foreign will, perhaps just for that particular asset, and we can work with the advisors over there and in making sure the two wills work together. Um, Corporations, we'll try to figure out if there's shareholder agreements, if the companies have significant value, then maybe there's an opportunity for dual wills, perhaps to reduce probate fees. So we might suggest strategies like that. Um, we'll also try to figure out, gosh, I can go on, I guess, but then we'll also try to figure out like if there's joint assets, what was the intent behind those joint assets? Like, why is this person on with you? Is it going to them? Are you both contributing? Like, what's happening here? And then try to document it or prepare documentation to support that intent if it's not adequate to begin with.
Yeah.
Uh, so it's really just yeah, figuring out the assets and what we're dealing with. Going back to the children, I mean, are we comfortable with all of them receiving their inheritance? Are trust needed? And I mean, clients are usually pretty good at kind of sharing a bit of information as well. Like, I'm concerned about this one child. They can't really look after themselves, or we need to kind of set up a trust. And clients are usually pretty good like that. Um, but I mean, I will say, probing questions can be very important. I recall this one client. Um, I think the question so I was trying to figure out his family.
Yeah.
So he had a spouse, I believe he said, and then he said, and I have three sons, right? I'm like, okay, good. And I could have just left it at that, but then I said, no daughters. He said, yeah, I do have one daughter, but she like we're just not. I'm like, okay, let's talk about this a little bit, right?
Ah,
So sometimes you do have to ask questions in a roundabout way, and yeah. So
wow.
like, on children, I'll ask like, are there any, they'll tell me, these are the names of your kids. Okay, great. I got Jane Doe, John Doe written down here. So no adopted children, no estranged children, no deceased. Like you got to work down that list, right? And just
Yeah,
get clients
absolutely.
thinking about it. Yeah. So
That's wild. And
yeah.
so something that we bump up against as financial advisors is blended family planning. It's not something that really was in the curriculum because a lot of the financial planning curriculum was kind of out of the 90s. And now it's like blended families is such a predominant, like it's most of the marketplace. How do you address that with clients when they're trying to do a will? Do you ensure that if the husband had a second or third family, or the wife had a second family, do you do separate wills that address all of that in an outward motion, like it's branching out? How do you deal with that?
Yeah, it often comes up. I mean, I just had a call yesterday. These are clients that I've worked with in the past to prepare wills. They're blended families. Um, And so previously, a lot of their assets were separate. So the will making process was a little bit easier at that time because the assets aren't joint. So if you have something in your name and you want to direct it a particular way, you can do that. It's in your name. But the call yesterday, things have changed. They've actually made a lot of things joint. And so they do understand now that the planning for this is a little bit more complicated
Yeah.
because, like the residence, for example, was previously just in her name, but now he is on title as well. And so the understanding now is that, yeah, the asset is just going to pass to the surviving spouse, so it may not actually form part of your estate. But their objectives have changed as well, right? They want to provide for each other first, and then the kids afterwards. And we might, carve out a bit of funds for the children that they receive something at the outset while the home passes to the surviving spouse, and then eventually makes their way to the kids. Um, but it really just depends on the client's objectives, how far they want to take it as far as planning. But there are ways to address it. Trusts, outright gifts to kids, beneficiary designations. Like these are all things that you can use to plan in those situations.
Okay. Okay.
Yeah.
Yeah, that's a lot. It's uh we've got some clients that have some very interesting, colorful uh backgrounds and trying to piece it all together and figure out who gets what and when and how, and it becomes less straightforward.
Yeah, you know what? Piecing it together is the right word because it is a puzzle, right? And so the takeaway from yesterday's meeting was that because they've changed, consolidated their assets and such, and I said, you know what? I'm going to send you an updated questionnaire for you to complete so I can figure out what you have. And then from there, we can kind of work through this and see, what's best going where. Like, oh, I want this to go to my kids and this to go to him and vice versa and so forth. And it's a puzzle.
Yeah, it is a puzzle.
Yeah.
From the beneficiary's point of view, um, if you are the beneficiary of, say, your great aunt passed away and she was wealthy, if you receive the inheritance, is that protected from separation or from divorce? Like, how do those inheritance laws work? Because I think there was an old way and there may be some new takes on that. How do you talk to families about that?
So I will caution. I have a general understanding of family, not my expertise. We have family
Okay.
lawyers that do that we work with. Our clients will work with them, and we'll kind of work together and solve those issues. But my understanding is that the Family Law Act, when it was introduced, did introduce some exclusions as well. So if you would receive inheritances, they're generally protected from future division of property claims, as well as assets that you typically bring into a relationship. But for all the listeners, that this is not legal advice. You
That's right.
must consult
Disclaimer.
directly with. Yes, yeah. But yeah, it's nice actually that the Family Law Act has kind of addressed this, and provided this protection to things like that. So, um, you know, if, so just to kind of walk through it, if you're in a relationship and someone passes away and now you receive an inheritance, generally speaking, that should be excluded from division of property claims.
Okay.
But if it increases in value, that increase in value might be subject to claims, right?
Okay.
So,
Okay.
yeah,
That's
yeah,
interesting to know. Yeah, I know it's kind of a nuanced topic and it can the like we say when our clients ask us complicated questions, the answer is usually it depends, and then
yeah,
we have to do some discovery and figure out like what's going on.
yeah, yeah. And we were talking about this yesterday with my clients, because they're like, what if one of us passes and the other spouse then remarries? And I said, well, that spouse should probably consider a prenup, right? Because they not only want to protect their own children, right, but also your children. So
Yeah,
that's another tool that can be used as well in those kind of situations.
interesting.
Yeah.
That's a great topic actually. Prenups in Canada, how how valid are they? Because we've had other opinions before say they make sense at the onset of the relationship, but as the relationship grows and matures, it may not be valid anymore or may not be as valid. What's kind of your opinion just generally on the idea of like, should everybody at least have the discussion? If you have a business or if you're a professional, you need a prenup? Like, what's kind of your take on that?
Yeah, I mean, it's important, especially if you are bringing children to a relationship as well, and you have an existing business, and the intent is that that business should pass to those children. And that's where a prenup could be useful, right? So um, that is something that our family lawyers do, and it's a tool that they use. So I imagine it's effective. And
Yeah.
um, your point about the validity of it as time goes on is an interesting one. I don't practice in that area, but that could be the case. I mean, maybe circumstances change, and then maybe that invalidates the prenup. But it seems unusual. I don't know if that's yeah. I'd be interested to learn more about that actually.
Okay.
Yeah,
Okay. Yeah,
yeah,
me too. Me too. That's why I
yeah,
asked. So,
yeah,
um,
yeah,
it's actually totally appropriate to defer to another area expert because we both want to know. Um,
yeah.
w- I guess I don't, we've kind of covered everything that I kind of wanted to talk about in terms of wills and stuff. When you are looking for like the ideal client to come in because you're the director of trust and wills and estates, sorry, with RDM. What are you looking for in terms of like clients that you like to work with?
That's a good one. So, I mean, we are different in that sense where um, it could be a very straightforward client with very straightforward needs, or it could be a very complicated client with complex needs. Um, and sorry, I don't mean the client themselves is complicated, but their situation might be a bit complex. So we work with the full spectrum in that sense. And our pricing generally reflects that. We have very basic pricing for basic needs, and very cost effective and affordable. And then clients that have needs that are a bit more complex, trusts, companies, etc. We'll often let them know as well what the pricing for this looks like, and most clients understand that their situation warrants this, and so it makes sense. Um, but I mean, my expertise is obviously in the trust area, in the corporate area. I do a lot of corporate work, so dual wills and probate fee saving strategies. I'll do a lot of work with that and setting up trusts. I love drafting. That's why I'm a solicitor. That's why I do wills. So I mean, drafting trusts is so if clients are in need of trust, that's what I enjoy doing.
Nice.
Um, but I mean, I like wills and estates generally, so it doesn't matter if the needs are basic or not. We'll assist, where we can.
Okay.
Yeah,
Okay.
yeah,
That's fantastic.
yeah.
Um, One question that I like to ask clients at the end of the interview is kind of like, what is one book that's influenced you in your professional or your personal life that really stands out to you?
Gosh, I wish I had time to read more books these days. I
Yeah.
feel like I'm always reading contracts or clauses and such. Um, I mean, professionally, I would say so. We have this organization that's geared towards lawyers. It's called the Continuing Legal Education Society or something.
Yep.
And they produce a number of publications which have been kind of instrumental for me as far as drafting, building my wills and estates practice, and perfecting wills and drafting of clauses and trusts and such. And so, I mean, that's been instrumental to me in my career, having that as a resource. Um, so, I mean, I would recommend that to anyone that's sort of in this space, doing work in this area.
Okay. That's awesome.
Yeah,
Never heard of that.
yeah,
I'm gonna
yeah,
check
yeah.
that out.
Yeah, it's
Um,
called Will's Annotated Precedents, and also I think the other one is BC Wealth Preservation Manual. Yeah, those are the two that are the good ones. Yeah, yeah,
okay. Nice.
yeah.
Um, what what podcasts are you listening to right now, if you listen to any?
Uh, I'll have to admit, I don't listen to any. I have three little kids, and so as soon as I get through that door, it is like dinner time, bath time, sleep time. It
Yeah.
is, yeah.
Okay.
Yeah, my
That
kids are
no.
three, two, and one, so we're kind of in the trenches right now.
Yeah. That's fantastic though. I
Yeah,
think that's the fun part, I think, for me. My kids are
yeah,
old now, and so I
yeah,
don't. I don't get that as much. It's more like, hey, can you drive me somewhere? Or like, hey, what's for dinner?
Yeah.
Or
But I'll be the newest subscriber to the Three Seasons podcast though, going that's for sure. Yeah.
oh, fantastic. Thank you. Thank you.
Yeah.
Really appreciate that.
Yeah.
Cam, if people are looking to get in contact with you or looking to follow like whatever you're doing, where do people find you online right now?
Uh, you can well, if you're trying to get in touch with me through the website is great. I mean, emails, phone numbers are all there. I'm not too active on social media, but I do have an Instagram account. I don't post a lot of professional content on there though. I mean, I did do a little bit around wills and estates. Uh, but uh, but yeah, that's another way to kind of connect with me as well. I think it's KSG Law is my Instagram account. Yeah,
Okay,
yeah.
fantastic. That's awesome. Cam, thank you so much for coming on and doing this. I really appreciate you taking the time. And I know we're going to have some follow-up questions. As soon as we get off, there's always something I forgot to ask. And so I'd love to have you back on again next year and talk about some other topics, especially corporate law. I think that's another area where we'd love to hammer down on.
For sure. And just one last thing, I am presenting at Yarrow Community Hall tomorrow. In case there are questions, I'd love to have you out there as well. I think that's at 5:30, and I'm doing a presentation on estate planning, and then I'm teaming up with Manning Elliott, so there'll be a tax component to it as well. So it might be of interest. But yeah,
Fantastic. I will let the
yeah,
team know. I'm sure somebody can show up.
awesome.
Yeah, fantastic. Cam, thank you so much. I appreciate your time.
Okay, thanks, Tyson. Yeah, have a good day. Bye.